Thank you so much for joining us for another edition of All Angles. I'm Dion Jackson. So it's a big year for the Caribbean Court of Justice. The court has been celebrating 20 years of existence. Can't believe it's 20 years. In addition to that, President Justice Adrian Saunders is stepping down as president. A new president is going to be assuming the top job at the CCJ. And I spoke to Justice Saunders via Zoom for an in-depth conversation about his feelings about the achievements of the court, where it is now and the way forward. Just a very quick reminder before we start that interview. You're going to be hearing a lot about what's called the appellate jurisdiction and the original jurisdiction of the Caribbean Court of Justice. Appellate jurisdiction just means when the court is sitting as a final court of appeal for countries like Barbados and Ghana. Jamaica is not part of the appellate jurisdiction. Our final court, remember, is the Privy Council. Then you'll hear about what's called the original jurisdiction. That means when the court is dealing with disputes under the agreement that established CARICOM. That agreement is called the Revised Treaty of Chaguaramas. Jamaica and other CARICOM countries are part of the court in the original jurisdiction. That's how the famous Jamaican case, Shanique Myrie, was able to go before the court. Later on in the program, we're going to be hearing from King's Counsel Hugh Small and Senior Counsel Leonard Green. But first, let's go to my interview with Justice Saunders. And we're joined now by Justice Adrian Saunders. Justice, thank you so much for talking to us on All Angles.
Thank you so much. I'm really pleased to be here with you.
I'm just looking at your, well, for want of a better word, your bio. I mean, named a judge of the Caribbean Court of Justice in 2005 when the court was just established. You've been on the bench since then, and you've held the post of president for the past 7 years. So this is a court now celebrating 20 years as well, as you say your goodbyes. So a number of important milestones there. Going back 20 years, what were your expectations when you joined the CCJ bench?
Well, I always had the highest hopes for this court as being a court that will embrace all the countries of the CARICOM and will carry forward our jurisprudence in ways that will emphasize our self-determination, that will strive to reach our best aspirations, and that will be the final court for the countries of CARICOM. We have done a lot of work at the court to cement the court's integrity, its trust and confidence, and it's just unfortunate that we only have 5 countries sending their appeals to us at this point in time. But notwithstanding that, I think we've made considerable progress, both in the original jurisdiction, where we interpret and apply the Revised Treaty of Chaguaramas, as well as in hearing the appeals of those 5 countries that send their appeals to us.
I was listening to you address the special sitting of the court at which they paid tribute to you. And you said to look at to gauge the true measure of the court. My words, not exactly yours. You said, don't look at the number of states that have signed on to its appellate jurisdiction, because you said that's just politics, untidy, disappointing, sometimes frustrating politics. And I was thinking, wow, Justice, tell us how you really feel. That sounds as if you're leaving with that aspect of how the court has developed, a lot of disappointment then.
Well, put it this way. I think that we have been able to do a lot in the 20 years because the countries of Barbados, Belize, and Ghana in particular, because Dominica and St. Lucia came on much later. But they have sent enough cases to us for us to demonstrate our mettle, for us to be able to prove that the court is worthy to be a final appellate court for Caribbean people, as if you needed to actually prove that. But at the same time, it has been, as I put it, disappointing and frustrating that there are only these 5 states. I really do think that politics, the interface between the political parties that are required to alter the country's constitutions in order to allow it to send their appeals to us, and the level of discourse between and among the political parties and the ability of those parties to reach consensus on an issue which really ought to be, in my view, a no-brainer, as the young people say. That is what is disappointing. That is what is frustrating, because I do think that the alternative is not sustainable, and I'm yet to hear a good reason for a CARICOM country not sending its final appeals to the CCJ.
When you say the alternative is not sustainable, meaning us having the Judicial Committee of the Privy Council as our final court of appeal, and why not sustainable?
It's not sustainable because there are several good reasons why a country that is cited, a court that is cited in London, that is staffed in the main by United Kingdom judges that are not experiencing the consequences of the decisions they make, who are not in tune with the aspirations and with a familiarity with the culture of the Caribbean people, that such a court should be left to decide our most important cases, our cases that secure our rights, our cases that determine difficult and ambiguous areas of the law, that we should be content to have such a court provide that role, that function, when there is a court in the Caribbean that has proven its worth, that has lived up to the challenges placed before it, and we not, support that court.
Are we stuck, you think, now, in terms of the number of countries that have signed on to the CCJ in its appellate jurisdiction? Is this as good as it's going to get?
No, not at all. I am supremely confident that in time, the other courts, the other countries will come on board. What we must look at is not just say, well, only 5 of 11 countries are sending their appeals to the CCJ, and therefore the CCJ is a failure. To me, that is not, and this is the point I was trying to make, that is not the proper metric by which we should assess either the success of the CCJ or the real opinion of all of CARICOM, including the other 6 countries that are yet to come on board, their attitude, their opinion of the CCJ. Because the court also addresses the CSME treaty, the revised Treaty of Shagaramas. And in that sphere of its work, all of the CARICOM countries send their matters to the CCJ. And if it were that countries were dismissive of the CCJ, if it were that countries did not believe in the decision-making of the CCJ, then there would not be the same level of regard and esteem that I see demonstrated in relation to our judgments in that CSME sphere of our work. All of our judgments have been obeyed, have been complied with in a timely fashion. All of the intimations that we have given in those judgments as to how the CSME should operate and measures that can and should be taken in order to make more efficient the processes that make the CSME run. All of those intimations have been followed, and therefore that is, to me, a much better indicator of the true opinion, the true attitude of states in the region towards the CCJ than their signing on in the appellate jurisdiction, because a number of extraneous factors impinge on the ability to sign on.
You suggest as well that the comparisons between the Caribbean Court of Justice and the Privy Council have been unfair, that the comparisons made between the CCJ and the problems in the domestic courts, you say, that same discussion doesn't take place in relation to the Privy Council. Can you tell us what you mean?
There are 4 factors that I think the detractors of the CCJ, those who go about saying, oh, let's remain with the Privy Council. The 4 main things which I have discerned that I consider to be not very good arguments. First of all, they're the imaginary fears. The fear that, okay, there might not have been any political interference in the past, but there can be. And therefore, we should stay with the Privy Council. Now, this particular position is wrapped up with the other position that suggests that, well, there is, the Privy Council is immune from political pressure, but the CCJ is not, and therefore we should stay with the CCJ, with the Privy Council, because we are certain that we would get justice that is pure, justice that has no hint of political interference. When a reporter asked me about this some weeks ago, I said it's rubbish. It's pure, unadulterated rubbish. There is zero evidence over 20 years that there has been any political interference in the CCJ. Moreover, the issue of immunity from political pressures has to do with your architecture, with your framework. And the CCJ has an architecture, it has a framework, which places it in a far more superior position than most other courts. We are the envy of courts throughout the world so far as the way in which we receive our funding. We don't have to rely on any government for a subvention every year. We have guaranteed funding from a trust fund that allows the court not to have to interface with the political directorate. That is an important measure that secures a court's independence. The way in which our judges are selected is a transparent and merit-based one, where the judges are selected by a group of persons, commissioners, who are appointed not by any politician, but by bar associations in the region, by law schools in the region. They come from civil society. So you have a broad range of persons who are only interested in ensuring that the best applicants are appointed. And so there is no platform on which there can be any political interference in the CCJ.
Couldn't I ask you though, Justice, if I could pause you just for a moment, aren't some of those same fears though, weren't some of those same concerns raised by the Privy Council itself in the CCJ case that came from Jamaica, the Independent Jamaica Council for Human Rights? The Privy Council essentially said, hey, you can't interfere with we, we're beyond political interference. The same is not true of the CCJ. So we have that in writing from them.
While I don't forgive Lord Bingham for making that statement, I could half understand it, because this was in 2004, and he was dealing with a court that had not yet started to operate.
Can I ask you to hold one moment, Justice? I'm right at the break. I'm going to pick up right at that point as soon as we come back. We're talking to Justice Saunders, the outgoing president of the Caribbean Court of Justice, and we'll be back in just a moment.